Good afternoon, possibly good morning, everyone. Thank you for joining us here today for what I have to tell you is the largest registered webinar ever held in the history of either the IBBA or the M&A source. So thank you for being here with us for this really interesting and exciting update today. We have members with us, we have affiliates with us, other professional advisors, some non-members yet to one of our groups, but hopefully soon in the future. And we welcome all of you because this is such a monumental time for our industry. It is also a bit of a confusing time, right? So we need to all learn, what does this mean and what still needs to be done when it comes to the particular legislation we're going to talk about here today. So we brought two of the gentlemen that have been on this for a better part of 2 decades to come and be with us today and really start with sort of an introduction on this thing. We're going to be talking about this for a while, but an introduction so we can all kind of understand where things stand as of today, what we know as of today, and what we know we have to put our eyes on moving forward. Before I turn things over to these guys, just a couple quick housekeeping items. We are recording this. I know everybody's going to ask that question. So yes, we're recording it and you'll have access to it after the fact. You have a control panel there on your screen that you can click and drag around to wherever you like it. You can also click on an arrow towards the upper left to completely minimize that out of your way. And you would click on that same arrow again to bring it back out. Now, there's a question section on your control panel. Please do use that if you have a question. We will save time at the end to go through those, at least 15 minutes or so. And I'm sure, again, we'll get through as many as we can in this intro session today. But thank you again, Mike and Shane, for being with us today. We appreciate your time, all the time you put in on this. Mike, I'm going to start off by turning things over to you because, you're the name actually we see all the update emails come out. You're the one you've been writing the articles and keeping all of us informed on the progression of this for so long. I don't want to spend a lot of time on the history, but maybe for somebody who's newer, giving them a little bit of an understanding of why this issue's been so important and what this battle has entailed before we jump into today.
Happy to do that, and thanks for the opportunity. This issue has been over our heads since at least 2000. The M&A source was concerned at the time that all of their members should become securities licensed if they were serious about being M&A advisors. And a couple of the successive chairs of the M&A source advocated from the podium that if we were serious, we ought to get securities licensed. In 2005, the ABA task force published a letter that was published in a legal journal that basically said there's a need to address this gray market where people are conducting so many transactions outside the law. And in response to an SEC follow-up letter, they said there's a need for a broker-dealer light for people who do capital raising. And a case could be made for exempting business brokers and M&A advisors because they don't hold the funds, they don't have the power to bind people to a transaction, and they're already regulated in many states by real estate law. And that was really the impetus for the formation of a committee that started as the Campaign for Clarity in 2006. And we engaged Warner Norcross and Hugh Makins and Shane Hansen to advise us. And the counsel was, we think that there's a case that can be made for exempting M&A brokers and business brokers. So that was the beginning of it. In IBBA independently had engaged an attorney and succeeded in getting the CBI no action letter in 2006. But the limitation there was it was really one transaction, and you had to sell 100% of the shares, and the broker had to basically back out and really not provide traditional brokerage services of advice and counsel on the valuation or the deal structure, etc. They were limited to transferring documents between the parties. And so the industry quickly recognized that that was not the complete solution. Prior to that, AMAA had engaged a task force that was looking at forming their own broker dealership. And they again saw that if there's an opportunity to get an exemption, maybe that's the direction we should go. So fairly quickly, by 2007, all of the national associations were behind the effort that we now call the Campaign for Clarity. And I must tell you at the outset that all that we've accomplished, and as long as it's taken, would not have been possible without the extraordinary financial support of the internet, of the national associations and the regional associations, and about 300 individuals that contributed personally. We put a lot of time in as volunteers, but none of this would have happened without the financial support. And in the dark days when we've been at it for 10 or 12 years and people thought this is never going to happen, the national associations continued to support this effort that's led to the bill that's now passed. The first time we introduced the bill in Congress, it passed unanimously through the House of Representatives. And 2 weeks after it passed the House of Representatives, the SEC issued the M&A broker no action letter, which was one of the most sweeping no action letters I think the SEC's ever written. And it had no size cap. That became a template that we used going forward, working with NASA and working with the Congress to get today's bill. And in 2015, the North American Securities Administrators drafted and formally adopted their model state rule that conformed with the SEC no action letter and the bill that we had in front of Congress. And finally, in December of this year, we were able to get the bill unanimously through the House and again added to the Senate omnibus bill for appropriations for the fiscal year 2023. And now we have a bill that will become the law of the land March the 29th. With that, I'm going to turn it over to Shane Hansen, who was the principal architect and the lead attorney since day one. And Shane's a better position to explain what's in the bill and what does it mean to those of us in the profession. Shane?
Mike, thank you. And thank you for the opportunity to give this presentation. As they say, it takes a village, but in this case, the village was nationwide. And there are kudos to go around for sure. The leadership of all the associations, a couple of people who have passed away in this process, not least of whom was Jeff Taylor, who was our Washington, D.C. lobbyist in all of this. And it has been the result of persistent efforts. I'm a securities lawyer. I'm with Warner Norcross and Judd, about 230 lawyers. Our headquarters is in Grand Rapids, Michigan, which just happens to be nearby Congressman Huizenga's congressional district. And I'll get to that in a moment. Let me just back up slightly to kind of connect the dots. Literally, the SEC staff was supportive from the beginning of our discussion in 2006. And we wrote and provided the SEC with a draft rule that would have accomplished this. And they were, as they say, that close to actually engaging in rulemaking in 2008. But the national financial crisis hit. Congress passed the Dodd-Frank Act, which had a huge laundry list of rulemaking. And so informally, the SEC staff came to us informally saying, you know, we're not going to have the bandwidth to do this by rulemaking. You should go talk to Congress. So we did. We wrote a bill that was widely vetted in the industry and associations. And Congressman Huizenga from West Michigan worked with Congressman Brian Higgins from upstate New York, a Republican and a Democrat. So from the beginning, it was a bipartisan effort. And as Mike said, the bill rapidly moved through the U.S. House Financial Services Committee. Literally the day the bill dropped in the House, I hand delivered a copy of the bill to the SEC staff because we were having a meeting about a no action letter at the time. And so this effort really has had parallel tracks really from the beginning, working with the SEC, also working with the state securities regulators through their association called the North American Securities Administrators Association, or NASA for short. I like to say that's the other blue sky people, and included a day-long program that AMNA, IBBA, M&A Source put on for state regulators in Chicago to educate them. Basically, what do M&A brokers do? And that paid dividends, because as this turned into the long haul, as Mike noted, the NASA, the state securities regulators, developed a model rule, not law, but a model, so that the 50 states, the District of Columbia, Puerto Rico, and even Guam would have a framework for developing state-level exemptive relief. And in the effort in walking the halls of Congress, we had NASA on our side, which is unique in making this effort moving through the Congress, having bookends of the U.S. Chamber of Commerce supporting us and NASA, the State Association of Securities Regulators, supporting us. And that is what really got this ultimately across the goal line. In view of the fact that Congress has basically been dysfunctional for roughly 5 sessions of Congress, that is 2-year sessions. This started in the 113th Congress, and we've just finished the 117th Congress, and we're into the 118th now. So as I get into this, let me highlight the fact that what I'm going to describe is really not legal advice. This is a description, summary, at really an introductory level of what this exemption does, what its guardrails are, and a little bit of insight into why the guardrails are there. And then also talking about the status where we're at with the states. We'll cover the scope of the exemption, we'll cover the conditions to the exemption, we'll cover the disqualifications that kick in to the exemption. We'll talk a little bit about compliance considerations, state level compliance. If we have time, I'll talk a little bit about FINRA. FINRA being the Financial Industry and Regulatory Authority, that's a self-regulatory organization, and SRO in government speak. And we'll talk a little bit about that, and then I'll throw it back to Mike for a discussion of fundraising and a few comments around other state laws like real estate licensing that are not affected by this at all. So with that, let me get into a little bit to say, you know, it only took 5 sessions of Congress, that's almost 10 years. And this bill has passed the House, U.S. House, 3 times unanimously. So the House was never a problem. And it only took $1.7 trillion to get the U.S. Senate to pass it. That's because it's part of the federal funding bill for 2023. It was added along by Senator Kennedy with about a dozen or so bipartisan, really almost all wide margins of passing the House. And so we are very fortunate to have this included in that. And so let me hit a little bit around the scope of it. So what we're doing basically in this exemption is by exempting M&A brokers, and that's a defined term in what is now the statute. It's in the Securities and Exchange Act of 1934. This exemption becomes effective March 29th of this year, 90 days after President Biden signed the law. And it's built around the really the differences between what is, in general, the one-size-fits-all system of federal regulation of securities that's really primarily designed for publicly traded companies and public markets, all having passive investors, and replacing that with a way skinny down set of guardrails designed around really the differences between M&A of private companies in contrast to public companies and passive investors. So core to this and included in a definition in this exemption is the notion of what is a eligible privately held company. That is to say, it's a private company. It's a company that has no class of securities registered with the SEC. Its securities are not publicly traded. It's a privately owned company. So that is a critical aspect of this, and it's in the context of an M&A transaction. And this is intended to distinguish this exemption from capital raising involving passive investors. So the definition of an eligible privately held company is designed to distinguish this from public companies. And M&A is important because, as we explained, the SEC got this, and the state regulators learned it, that M&A deals are privately negotiated. Sellers, buyers, lawyers. This audience understands that also well. That no one runs to the SEC or to a state regulator if something goes sideways in an M&A transaction. It's a negotiated definitive agreement, whether it's a stock purchase, a stock exchange, a merger, some other kind of form of business combination. All of those things are covered as long as it's a privately held company. For political reasons, we ended up including some size caps. As Mike noted, there's no size cap in the SEC staff no action letter. That's because the SEC had done no economic analysis that would be required by law for the SEC if it engaged in rulemaking. But what is obvious to all of us is the larger the deal, the less need for the regulators to be involved. There are more lawyers, accountants, larger companies have larger management and executive C-suites and support. So the no action letter has no size caps, but the size caps were really a political necessity because we knew we would run into opposition from the Wall Street Investment Banking Trade Association, better known as SIFMA, the Securities Industry and Financial Markets Association, who were not ultimately opposed to our legislation, but they did want to lower the size caps to a point that it was not going to be useful. So it was good that we included size caps in order to get this passed. The metrics and the thresholds widely vetted within the associations, and they're alternate size caps. One is a gross revenue size cap, the other is an EBITDA size cap, and the dual alternative metrics are intended to account for the fact that some companies have high volume, low profits, others have low volume, high profits. And so the size caps are $250 million in gross revenue or $25 million in EBITDA. That's based on actual historical financial results carried on and reported in the books and records of this target company or the eligible privately held company. Not adjusted, it's the actual financial performance of the company as of the fiscal year end immediately preceding when the M&A broker is hired. Not adjusted because that just completely opens up the world to a lot of monkey business. It's actual results. and its actual results of the fiscal year end immediately prior to the M&A broker being engaged. And so that is important because it takes a lot of the guesswork out of this. The other conditions have to do with the buyer. And this again is in the nature of private company M&A transactions. So for the M&A broker to rely on this exemption, the M&A broker has to reasonably believe, and that would really be at the time of the engagement, because we all know these engagements take months, if not years, to be completed. But the M&A broker needs to reasonably believe a couple things. Number one, the buyer, whoever that might be, is going to acquire control, a controlling interest. And there is a presumption of that controlling interest at 25% ownership. So to Mike's point, the CBI no action letter had the whole company having to be sold. And in our first meeting with the SEC staff, they were willing to go down to 50%. Well, we've got it all the way down to 25%. So, and that's a presumption that the acquired interest is at least 25%. Could be more, but at least 25%. So that's one prong. The buyer has to be acquiring a controlling interest. The second is that the buyer is going to either directly or indirectly be actively involved in the management of the target company or the company that's created out of the assets that are acquired in the transaction. And the exemption, just like the no action letter, includes a variety of examples, non-exclusive, but for example, could include being on the board of directors, being in an executive C-suite role, could be included in approving the operating budget of the company. So again, both of those things, 25% ownership or more, and being active in the management and operation of the company, directly or indirectly, doesn't mean that you have to be there every day. But it fits, for example, if the acquisition were to acquire an entity that becomes a subsidiary of the buyer. It could be a private equity firm and fund that is acquiring a portfolio company, adding it to the fund's investments, and where the fund through the PE firm or the venture capital firm is providing the active management and control that satisfies that definition. So those are the basic parameters around the eligible company, its size, and the buyer's role. There's one additional thing in the exemption that is not in the no action letter, and that is to be sure we had this covered. In some transactions that are not cash, some transactions the buyer may issue its own securities. So for example, a merger. If you're going to exchange the stock of the seller and the buyer in a merger, the buyer becomes an issuer, issuing the securities that will be received by the seller. And that is covered by this exemption. In that context, and this is less common for sure, but it is covered by the exemption, again, with the M&A brokers having a reasonable belief that the buyer is going to provide the seller, who is essentially becoming an investor, with the financial statements of the buyer, including a balance sheet within 120 days of the offer of the securities, and including any CPA issued audit letter, review letter, compilation. In addition, including the management discussion and analysis, not a public company version, but essentially some discussion around the company's performance by the management team. And in addition, discussing material loss contingencies that the buyer faces. These are all things that a seller's counsel would typically ask for, would include reps and warranties in the definitive agreement, because the seller is going to be stepping into the role quite often, either being an investor or a creditor. And so these are things that routinely would be included if the buyer is going to be issuing its securities, whether equity or debt securities. So Mike, let me stop there before I go on to conditions, disqualifications, and compliance. Anything you'd like to add to that? You're muted, I think.
Yeah, I think you're covering it very well, Shane. And I think we're going to give the audience a chance to ask their questions. I think better save the time for them.
Fair enough. So, so the conditions of the exemption are really designed to be guardrails that are very, very attuned to private company M&A. These are the kinds of things that pretty much routinely happen anyway. They are designed to basically substitute for very extensive SEC rules and FINRA rules that regulate public companies and M&A of public companies. These are much more specific, and each of these address concerns the regulators would have and did have in sort of letting go of the reins of the one-size-fits-all regime to a very tailored regime for private company M&A. The first one, and maybe among the most important, is that the M&A broker cannot have custody, control, or possession of the funds or the securities that will be exchanged by the parties. This is because this is a risk of theft, that somebody like Bernie Madoff made off with the money. And so this was very important to the regulators. So what does that mean? It means you cannot hold earnest money deposits, but instead you could work with a title company, a bank, an M&A lawyer, but very commonly it's simply the seller and the buyer in the definitive agreement provide for a closing, and at closing, when all of the other conditions to closing have been satisfied, there's a wire transfer between the banks, and the M&A broker never touches it. But in fact, to qualify for the exemption, you have to be sure you don't touch it. So that's one of the conditions: no custody, possession, or control. The M&A broker cannot be engaged in a public offering of securities by the issuer. What does that mean? Well, it means that you have a private company M&A transaction that involves securities. That's technically, under securities law, a private placement of those securities in the transaction. The securities are not registered with the SEC. They're not tradable on a public market. But that's an important distinction, again, to give up the one-size-fits-all regime and make it substituted with just the general condition that it cannot be a public offering of the securities. Next condition is that the M&A broker, either directly or through an affiliate, cannot provide financing for the transaction. The rationale for this is essentially this: that financing the transaction puts the M&A broker in a significant conflict of interest, because not only are they going to get a success fee, but they're also going to have compensation related to the financing. So that plays out this way. So a commercial bank or a private equity or venture capital fund and the PE or VC firm that manages that fund cannot rely on this exemption. And that's simply because they're providing the financing in the transaction. They can be an investor, they can bring capital to the transaction, but they cannot act as the M&A broker or get a success fee on the transaction. The M&A broker cannot facilitate or form a group of buyers to be able to basically syndicate the transaction. This too looks very much like a conflict of interest in pulling a group of buyers together. And that kind of conflict of interest becomes a concern to the regulators and would be regulated in a public company transaction. So cannot form or facilitate the formation of a group of buyers. Next, and almost to state the obvious, it cannot involve the sale of the business to passive investors. That's the whole point that distinguishes private company M&A from public company M&A, is that there are no, on the buy side, no passive investors. You got to get at least 25% control and be active in the management or operation of the business. The last condition is really kind of a derivation of what happens in public company retail brokerage. The M&A broker cannot bind a seller or a buyer to the transaction. And you kind of go, well, what does that mean? Well, think of it this way. In retail brokerage, you or I would go to our stockbroker and say, I want to buy 5,000 shares of General Motors. And the broker would put an order in to buy 5,000 shares of General Motors. The broker is legally binding the customer in that transaction so that when the trade order settles, the buyer is required to pay the money. And so they're legally bound. So this condition is intended to distinguish that. And again, easily satisfied because we know that sellers and buyers typically have their own counsel. They have definitive agreements that provide for closings, and the intermediary, the M&A broker, is not in a position to have a power of attorney to be able to legally bind either of the parties to the transaction. Now, it's important to note there are a couple of can-dos. That is, the M&A broker can introduce a buyer to a prospective third-party funding entity. It could be a commercial bank, it could be a private equity fund. They can introduce them. They just can't be associated or affiliated by control or ownership with them. It does require disclosure because the fact that an M&A broker introduces commercial financing to the transaction, and particularly if they're going to get paid for it, is a conflict of interest. But as long as they're not affiliated, that's key. But as long as the M&A broker discloses the fact that they are going to introduce a buyer to the commercial funding or commercial finance of the transaction, and whatever compensation they are going to receive as a result of that. And the other can do, this is more Main Street than middle market M&A, but it is that the intermediary, the M&A broker, can be a neutral intermediary, where the intermediary actually has dual representation and service to both the seller and the buyer. And that is also permissible, particularly, as I say, this is more common in what we'll call Main Street transactions. Does require disclosure, does require consent from the seller and the buyer to recognize the conflict of interest, with the intermediary basically playing the middleman in a neutral capacity. Mike, you were going to say something.
But you've covered it. So
Okay,
I was going to say that it doesn't prevent you from introducing buyer to a private equity group or to a finance, so long as there's disclosure. And you've already covered that.
Okay, gotcha. Really, lastly, in terms of the exemption, there is what we would call disqualifications of the M&A broker. And that is the M&A brokerage firm or the professionals, the officers, directors, managers, members, people who control it, cannot be barred from the securities industry. That is to say, kicked out by a regulator, by the SEC, by FINRA, by a state, and cannot be suspended if they are registered with a broker dealer, cannot be suspended from that, again, by a regulator. And the premise for these disqualifications is pretty obvious, that they are intended to prevent somebody who's a bad actor and has been kicked out of the industry from coming back through the back door to be able to receive compensation in connection with an M&A transaction. So those are disqualifications. If you fit that, then you are not permitted to rely upon this exemption. Quickly, let me hit some of the compliance considerations around this exemption. Number one, the exemption is self-executing. There's nothing you have to file, nothing you have to record keep even. It is always prudent to be able to prove that you have a reasonable belief on the points that I mentioned earlier. But that could be reflected in your engagement letter with the seller or the buyer that describe the transaction that you are going to help them achieve, where the buyer will acquire at least 25% and will be active in the management and operation of the business afterwards, directly or indirectly. And so it is just a registration exemption. That means these are securities transactions. Simply, though, you, the intermediary, do not need to be registered with the SEC as a broker dealer. It's still a securities transaction. So if you're exchanging stock or you're exchanging securities, the SEC still has jurisdiction over all things securities. And the federal and similarly state anti-fraud prohibitions that are in the securities laws continue to apply. So it is just an exemption from registration. But when I say just, it's a huge just, because if you're not registered with the SEC, and not required to be, that also means you do not have to be a member of or registered with a member of FINRA. FINRA's jurisdiction is entirely based on being a member of FINRA with a membership agreement with FINRA and or being registered as a professional with a FINRA member. FINRA's jurisdiction is entirely contractual, and it's entirely driven by the SEC saying you have to be registered with a broker dealer that's registered with the SEC, and this exemption says you don't have to be. So it exempts both the M&A brokerage firm and the professional from being needing to be registered as or with a SEC registered FINRA member broker dealer. So next up, it does not preempt state law. State securities laws also regulate brokers, just like the federal law does. A broker being defined as a person engaged in the business of effecting transactions involving securities on behalf of others. Very simple definition, broad sweep, and that's why we've been working on this for almost 16 years, because it's such a broad sweep. We now have this exemption. We have the exemption federally, and we have at the state level 20 states on board to date. that have either adopted NASA's model rule that Mike mentioned earlier, and there are 12 out of the 20 that have adopted NASA's model rule, and there are 8 out of the 20 that have adopted a no action position, basically saying that we, the state, will, just like the SEC staff's no action letter, will not recommend enforcement. The most of these state no action positions incorporated the size caps from the federal legislation on which the NASA model rule was predicated. So we can anticipate that in the coming months, those 8 states probably will update their no action position. And then what it leaves to be done is the other 30, and plus the District of Columbia, and if you want to count it, Puerto Rico and Guam too. And so there is more work to be done. Those 30 states, we believe, will be more interested now that the federal exemption has been adopted and becomes law March 29th of this year. The states are more likely to take action on their part through lawmaking, and that is kind of outside of the agency level. That's not what state employees do. It means the associations, state and regional associations, will want to talk with their state legislatures or with their governors, and particularly the economic development agencies within your state. And it's helpful to do this with the imprimatur of the association, so it's not just one person asking. It's also fair to say, ask your regulator. So if you don't ask, they probably aren't going to do anything that would take their time, staff, money, because state rulemaking has an extensive process in all 50 states. That is how there's public comment, notice, and it's a process. And the state regulators are unlikely to do that unless they're asked. And I would say out of the 20 that have been early adopters, did so because they were very actively involved in this whole effort. And Mike and I will be sure that in the links to the recording and the follow-on, you'll get a list of those 20 states going forward. And with that, Mike, why don't I toss it back to you for a discussion around, I didn't mention the state real estate regulation of business brokers and real estate licensing. Those are not affected by this exemption because it's a federal exemption, does not preempt state law. And then talk about the fundraising efforts.
Very good. Well, thank you, Shane. And we want to leave some time for questions. So I'm going to be brief. The next steps that we need to accomplish, as Shane said, is to work individually with your respective states if they haven't already adopted a harmonizing rule or a harmonizing law that exempts business brokers and M&A advisors from state securities law. And then the other thing that Shane mentioned is that the exemptions from securities law at the federal and state level have no bearing on real estate law. So if your state requires a real estate license in order to do business brokerage or M&A transactions, you still need a real estate law, or you still need a real estate license. The other thing that we're wanting to do is raise some additional money. We have spent in excess of $1 million in legal fees and lobbying expenses, and we still have some legal bills to pay, and we'd like to leave some dry powder in the beef treasury for whatever the next issue is that may come down the pike, and we need to organize a profession-wide response to. So one of the things you'll be receiving via email is a contribution card, and we would encourage you to make a meaningful contribution to pay the bills that we've incurred to get this milestone legislation enacted, but also to leave the association in good shape for whatever the next issue might be. And there are some matching funds that are being organized by the various associations. I'm aware of effort at the national level. I'm aware of a couple of states that have already committed to matching state funds. I'm aware that Trans World is already committed to a matching fund for their members and affiliates. So be on the lookout for that, because that will multiply your generosity. With that, I think Kylene may be gathering some questions that can be addressed to either Shane or I, and we'll be happy to take as many as we have time.
Oh, yes, indeed. We have questions for sure. I want to make clear for folks, because some of the questions that have been coming in are just a little bit confused. Shane, your repeated use of the term M&A broker was really, I think, because that's how it is specifically written in the legislation. But let's be clear, what we're talking about applies to anybody who found themselves being an intermediary on a transaction that involved stock. And typically, if somebody's working in Main Street, upper end of Main Street, something can start as an asset sale. And then for a variety of reasons, often tax reasons, that can change and go to a stock sale. And the historic issue has been, is like, well, technically, once it's a stock deal, you know, are you subject to securities licensing requirements? That's what this whole issue is around. And so people are asking about, well, if I'm doing deals between these ranges, well, it's not really just about price. It's about the structure of your deal. And if at any time it went to being a stock deal, you had exposure. And we know, unfortunately, of folks who found themselves caught in this issue because it went to a switched, you know, formats, went to a stock sale, and the intermediary got burned in those situations. So this legislation is going to help protect you. I think that's, I just want to throw that out there and clarify that for some of the folks that have been sending some of these comments in.
Yeah, absolutely.
Yeah.
Great, Kylene. Good questions, I would say. Yeah, the whole premise for this exemption baked into the Securities and Exchange Act of 1934 is that the whole premise for it is that a transaction and the role of an intermediary in the transaction, M&A advisor, a broker, a consultant. You're absolutely right. The term we use to kind of capture that whole concept of an intermediary giving advice about an M&A transaction, whether it's sell side, buy side, preparations, or all the way to closing. It's securities laws jurisdiction triggered, and that is when the legal structure of the transaction changes or starts out as even the sale or exchange of stock. LLC membership interests can be securities. Again, think of it really almost as simply as this. Are there passive investors? So with an LLC, for example, if it is a manager-managed LLC, that is really kind of the same characteristics of a corporation, having a board and officers, because a manager is acting on behalf of the members. And that typically means, not always, but typically means the members are passive. Some of them, at least, are passive. And so it's when you trigger the federal and state securities laws that this exemption becomes protective of your engagement and all of the work that you put into it. Because federal and state securities laws have, like most regulated professions, they say basically you can't get paid if you were required to be registered or licensed under, in this case, securities laws. You can't even get reimbursed for your expenses, because as a matter of public policy, it becomes a way someone can basically work around and avoid the regulatory regime. So and so I'll conclude that point by saying that typical Main Street and middle market M&A, cash for asset transactions, all cash for all, all assets, or whatever assets, typically does not involve securities. So you're golden in those. Now, small companies typically either own or lease real estate. So in an asset sale, you're selling a real estate or you're assigning a lease, you probably have to have state real estate licensing in order to do that. But that's not a security. That's not what this exemption is all about. This exemption is under federal securities laws.
Eileen, this is Mike. I'd like to make one clarification. A mistake that I see a lot of your audience or a lot of my peers make is they think that it's just asset sales versus stock sales. And even a cash for assets transaction can include securities. In some cases, if it's simply a seller's note that's not well defined, or if it's an earnout that depends upon the performance of others before you know how much money you're really going to get. So it's really any transaction that involves securities is covered by securities law. It's not just the classic stock sale.
Great point, Mike. I think that piece of it is often, not talked about enough. You're right. So
I would just conclude that point by saying that, and the beauty of this exemption is that there are not a ton of things you have to do to comply with it, and it's there to protect you. If through no fault of your own, the parties decide to restructure the transaction after you've been working on it for a year or 18 months and decide to turn it into a transfer or exchange of securities, you're still covered.
I think this will answer a couple of folks' questions. Somebody asked about sort of those baseline requirements again, and I can just read off of my personal notes, which I think are accurate. Shane, you can correct me. Basically what you're talking about is a M&A transaction, which is a defined thing, that meets the requirements of 250 million gross revenue and or EBITDA of 25 million. That's actual financial performance, not adjusted. A couple folks were asking about those numbers again. So I'm just going to restate those.
Correct.
Eileen, let me footnote that one of the concerns we had as we were talking with the regulators is we can't, as intermediaries, be held hostage for a transaction that may not occur for a year or two from the date we were engaged. So the metrics apply to the last fiscal year before we were engaged. So you don't have to wake up one morning and discover that your transaction suddenly involves a company that is bigger than the metric. If the book EBITDA and the gross revenue meet the metrics we've described in the last fiscal year for which you have financial statements, that's the measure.
Great point. Great point. Some more specific questions here. And again, we'll get through as many of these as we can, but also folks, yes, a couple of you asked, will more information come out? Yes, this is the start of a process, this introduction, and I can tell you we're going to be talking about this at the upcoming IBBA and M&A Source conferences in May in Orlando. So plan to be there for that. A lot of questions about, hey, you talked about these states. Where do folks find sort of that state level information? How do they know if they're in the 20 or if they're in the 30 or in the 8 that did their own thing? Like, how do folks know that?
We have a list and we'll make that available. We'll send it to you, Kylene, so that you can post it or email it around. It's a one-page slide list, and it gives the citations to, in Florida, for example, the law, and in 11 other states, the rules. And then the 8 out of the 20, the exemptive order or letter. I believe that Nevada may be the 21st state. I think they have rulemaking in process to adopt the NASA model rule. And so now, as we look forward, the effort really is, because everybody has multi-state transactions, State jurisdiction, it's actually a good segue to the comment. State securities laws jurisdiction is triggered by where you, the intermediary, are conducting business. So we'll call that your home state. If you have more than one office, you have more than one home state. And where the seller is located and where the buyer is located. And so in a common multi-state M&A transaction, you could have it at least 3 states having jurisdiction under their securities laws. And let's say, for example, you decided you were going to close in New York City and go out on the town and celebrate afterwards, you'd add yet another state, because where the communications occur, whether it's outbound from you or inbound to a seller or a buyer, or where the parties are closing or negotiating, technically those states' jurisdiction, securities jurisdiction gets triggered.
Yeah, thank you. We had questions
Eileen,
on
this
that,
is
so
Mike.
you've addressed that. Yeah, Mike.
Yeah, I think it might make sense for the associations to have a web page that we can continually update as more states get added to the list, because this is going to be dynamic, and hopefully one day all 50 states will be represented. But it might make sense for the associations to have a webpage that's accessible only by your members to see just what states are covered now.
Yeah, both IBBA and M&A Source do have web pages up around this issue on their respective websites. Expect that that's where we're going to be loading the latest and greatest information and trying to keep up on everything, folks. So you can always check in there, and we'll definitely get that information from you, Shane, about the list of states. That'll be really helpful, and we'll put that out there. I'm going to try to get another question here, time permitting. If a business has numerous important contracts which will not inure to the buyer in an asset sale, may the broker be the one who suggests that the parties structure the transaction as the sale of the selling company's shareholders' stock?
And the answer is yes. The exemption has been designed so it really doesn't matter who decides, the seller, the buyer. And and really this was a pitch we made to the regulators and to members of Congress. It eliminates what would otherwise be a conflict of interest that the M&A broker would have, because under prior law, an asset sale, cash for assets, was good to go. But the fact that it were structured as a securities transaction, then there was a requirement under the prior law that you be registered as or with a broker dealer. And that's a conflict of interest, that you would recommend one legal structure over another legal structure. And this eliminates that conflict. That was one of the points we made in lobbying for this bill, is it shouldn't matter. The seller wants to sell the business, the buyer wants to buy the business, the economics subject to tax considerations are essentially the same. And so the exemption here alleviates that conflict. The intermediary can suggest alternative legal structures, doesn't matter. Seller or buyer, their lawyers, their tax accountants, anybody can suggest it. Transaction can be structured. It doesn't matter. If you fit the exemption, you're good to go.
And I want to remind folks too, you said it, Shane, I'm just going to say it again. We'll try to get another question or two in, but nothing in this presentation today can be construed as legal advice. Listen, folks, at the end of the day, you're going to have to, if you work on these kind of transactions, you're seeing this with any regularity, you need to get some good legal counsel, somebody who's competent in federal and state securities law, to really help you through this. But we want to arm you with sort of the basics and these guardrails. Talk about guardrails. I like that term. So keep that in mind. I'm going to go to another specific question here. What if you sell a private company and seller rolls equity at 20% or 30% into the new company? Is this allowed?
It is. And that's in the nature of the transaction involving the sale or exchange of securities. And essentially the seller rolling equity into the buyer is an exchange of securities. It's making the seller an investor in the buyer, and that's covered. You would find in the definitions, it's now the statutory definition, I'm pleased to say, of an M&A broker defines the kinds of transactions that this applies to in the broadest of terms. It even uses it's a purchase, sale, exchange, issuance, recapitalization, reorganization, and any business combination. So it's in the broadest of terms, goes way beyond where the no action letters used to fall. And so the legal structure and the rollover of equity is covered. Key things, again, you got to satisfy the terms of the conditions in the definition of a privately qualified, privately held company. But that's what we all do.
Someone has asked, their firm has an escrow account that we use to hold buyer deposits. Is this permissible under the new legislation? I'm going to say that's a no based on what I heard you say.
That's a no. Again, the reason for this, it doesn't seem arbitrary. The reason for this is the regulators are very concerned about the ability of someone either holding or having control or somehow directly possession or control over cash or securities that just like Bernie Madoff can make off with the money. So that's a definite no. But what that means is you need to work with a commercial bank that has escrow services, title companies, third party, not affiliated with the M&A broker, but there are plenty of third parties out there who can serve that function. It might add a little bit of cost to the transaction because you're paying a third party escrow agent in the transaction, but that can be a reimbursable expense at closing. And again, the key thing here is the regulators want to avoid someone having the ability to steal the money.
I want to just do a time check with you both. I know you've been so generous with your time all along. Do you think we have time for one more question?
Sure.
Okay.
Absolutely.
Can your commission, this would be to the intermediary, be in the form of stock of the seller of a new entity that merged with the seller?
It can. The whole premise for this is, again, the legal structure of the transaction doesn't matter. And the exemption doesn't get into the either the regulation or control of the form of compensation that the M&A broker receives. It'd be fair to say that if the M&A broker received stock in the transaction, that would be restricted stock. They couldn't turn around and resell it. It would be a private placement of securities. It would have to comply with federal and state regulation of securities offerings by the issuer, whoever is issuing the securities. But the M&A broker exemption is not at all affected by the compensation or the structure of how the intermediary is compensated for services.
And I know I asked you for one more, but let me, because I got a whole bunch of questions coming in that sort of fall in this bucket where people just don't understand which rule supersedes. So from a conceptual standpoint, let's start with this. This changes nothing about the real estate license requirements that your state might have that say, if you're a business intermediary, you must hold a real estate license. So let's address that one. And then in terms of, I don't know, what do we call that, pecking order, your state needs to adopt this legislation. And what you have said is we've got 20 states that are on board.
Yep.
12 of those basically have everything we've talked about as their legislation?
It's a rule, but yes, one
Is
of them
a
has
rule.
by
Okay.
law, Florida, but yes.
Okay. Then there's like 8 states that have something else that's not this, but we're hoping they'll come over to this. And then so there's 30 states that need to get this adopted. So right now, the truth is, and then first of all, none of this, even at the federal level, goes into effect until March 29th.
Correct.
So
And
if you happen to be in one of the 12 states whose rule matches this, then you're completely good to go.
correct. And the rule, the state rules have a couple of nuances that eventually will get reconciled. The state rules are the state rules. The model rule was predicated on what was the then pending federal legislation in 2015. A little water under the bridge since then. And the model rule had a 20% ownership threshold. So it went actually 5% lower than the final federal rule. I'm fairly sure that eventually the states will raise their threshold to match the SEC's threshold. Again, that's simply the presumption of control with that level of ownership. Connect the dots with your question, though. The preemption, there is none, to be clear. This is an exemption under federal securities law, so it needs to be a securities transaction to even matter. Cash for assets not involving securities, none of this even applies. So you're good to continue as you were doing. And really the takeaway here is that the exemption really is designed to be unobtrusive, shall we say. It's designed to pretty much fall into, as long as you're at least cognizant of what the guardrails are. But they are very broad, very generous guardrails that would generally be available.
Let me just say, with the experience I had in Florida, that I found the Florida regulators and the Florida legislature very eager to harmonize state law with federal law. And they saw, because Florida is such a populous state, we have so many business brokers, maybe it's the birthplace of business brokerage in terms of how many years we've been doing it. They saw the need to get quickly out in front of this. Even before the federal law became law, there was a no action letter and there was a NASA model state rule. I personally expect that a lot of states, maybe not all, but a lot of states, if prodded, if asked, if approached by the state association, will be eager to harmonize state law with federal law. If you don't ask, they're probably busy doing something else and may never get to it. But if you make the case that this has changed at the federal level, the other states have adopted it, let's get on board. I don't think you're going to have a difficult time with most states getting them harmonized with federal law.
Well, thank you again so much. We're going to have you both back because lots of questions that have come in. Again, folks, yes, this has been recorded. We'll let you know how to get to the recording. Yes, we'll get the list of states out that we keep referring to. And yes, there'll be more information to come on this for sure. I'm sorry, Shane, you were going to add something.
Yeah, I would just add this. We'll send you, everyone should actually read the exemption. It's not long. It's 5 pages out of the Consolidated Appropriations Bill for 2023. That is to say 1,650 pages of federal spending. I'll avoid the political commentary, but read the exemption. It's as plain English as securities lawyers can make it. It is written in the context of the Securities and Exchange Act of 1934, so there's some formality to it, but read it. It's not very long.
Great, and we provided that link to the actual text in the emails talking about this webinar. We will make that link available to everyone again. So yes, thank you so much. Appreciate you and the army of folks really too. I know that both of you two represent that have been behind this.
Thank you for the opportunity.
Take care, everyone, and enjoy the rest of your day. Bye-bye.
Bye-bye.